Now, this is a subject I hear a lot of people talking about online with great authority. I figured with the holiday season coming fast upon us, it might be useful to bust some myths here and demystify the question on when you can and cannot buy a gun for someone else. So grab your straws and let's figure this out.
While the host of Fuddbusters is a lawyer, he is not your lawyer. If you pay him, maybe, either way you slice it, the video that you are about to watch is not to be construed as legal advice.
I'm sure you've heard all kinds of stuff online about straw purchases, and I'm sure you've read plenty of conflicting accounts. Lots of online forums and different chat rooms will leave you confused. Can you buy a gun for a gift? For your uncle, your daughter, your barber? Some will say absolutely not. Others will say yes, but only after you do a special dance. Now, before we get too deep into it, let's talk about the word straw purchase itself. In the gun community, it seems the word straw purchase automatically means crime. Well, the truth is a little different. A straw purchase, also known as a nominee transaction, is any purchase where one person agrees to acquire something on behalf of someone else. There's nothing inherently illegal about a straw purchase in and of itself. If I hand you some cash and say, hey, I don't want to go to the gas station right now, could you go there and grab a pack of hentai mags for me? And you do it, that's a straw purchase. And there's nothing wrong with it at all. Now, there is such a thing as an illegal straw purchase, but it has specific qualities that make it illegal. Of course, we're going to be talking specifically about federal law here. As always, there may be laws and policies that have different results on the state and local level. Now, when we're talking about illegal firearm straw purchases, there are three parts of federal law that come into play, and they are sections 2, 922, and 924A1A of Title 18. Now, let's parse through the law and then apply it to a bunch of common examples. Now, first of all, 922G, H, N, and X are where we have the list of people prohibited from possessing firearms at the federal level. It includes felons, dishonorable ex-military folks, defective folk, and more. 922D, on the other hand, makes it separately illegal to sell or otherwise dispose of a firearm to a person the seller knows is prohibited under those previous sections that we talked about. 924A1A makes it a federal crime to make any false statements on records that FFLs are required to keep, such as the Form 4473. This one is going to be important. Finally, Section 2 of Title 18 stands for the proposition that anyone who gets another person to commit an offense against the United States is punishable as if they did it as the principal actor. So those are the sections most pertinent to the topic at hand. Now let's talk about a few examples and we'll navigate through this minefield together. Let's start out with the two examples the ATF gives us in the instructions attached to the 4473 itself. The big issue here is question 21A on the form, which asks whether you are the actual transferee or buyer of the gun. Okay, example. Smith asks Jones to buy a gun for him. Smith gives Jones the money and Jones goes to buy the gun. Was a crime committed? Well, let's assume Smith isn't prohibited. The question is Jones the actual purchaser here? ATF is of the opinion that he is not and does little to explain this position, so I'll try to fill in the gaps of their logic here. In this situation, Jones was given a specific order and directions by Smith. If it were a legal straw purchase, such as for a car or a pack of gum, Smith would have a legal right to the property that Jones picked up. I think that's the best way to look at it. Jones is not the actual buyer because somebody else has an equitable claim to that property. Jones has no intention of keeping it, and he's getting it just to fulfill his deal with Smith. Since Jones is not the actual purchaser, if he marks no on the form, well, he won't get the gun, and there won't be any crime. However, if he marks yes, he's made a false statement in violation of 924A1A. Further, Smith is possibly guilty as a principal under the same subsection given Section 2 that we discussed earlier. Now let's say Smith is prohibited. Under the same circumstances, even if Jones marked no on the form, he may have still committed a crime. We'll talk a little more about that later. All right, next fact pattern. Mr. Brown walks into a gun shop. He sees something and goes, oh damn, Mr. Black can own guns legally, and he loves guns like that. Mr. Brown buys, with his own money and under no direction from Mr. Black, the gun, fully intending to later give it to Mr. Black. Is this a problem? Well, even according to the ATF, No. So here, even though he intends to give the gun away, he can still mark yes on that question because he is indeed the actual buyer. He is the only one with rights to it at this point. All right, let's move on. Douglas is hanging out at a park. There's a gentleman there at the park feeding ducks, and he offers to sell Douglas a very cool gun. Douglas hates the gun, but he knows his friend Stephen likes that sort of thing. They all live in the same state. Douglas calls Stephen, who is not prohibited. Stephen says, "Yes, please get me the cool gun. I'm sending you the money right now." Stephen sends the money to Douglas, and Douglas buys the cool gun and brings it to Stephen. Was this okay? Well, if we're just looking at federal law, yes. Nobody is getting a gun for a prohibited person. But what about Douglas not being the actual buyer? Well, in this situation, a private sale, nobody's filling out a 4473 unless there is no false statement in violation of 924. Now, if Stephen or Douglas were prohibited and the other party knew or should have known about the prohibition, that would be a problem under several sections. And if this duck feeder guy is doing this as a business, he is also committing a separate crime. But if it's just a normal private sale, all good to go, absent any countervailing state law. Okay, next up. Let's imagine Mr. Beauregard, who recently renounced his United States citizenship, wants to show his love to his drug dealer, Chuck. Beau heads over to the park, the same one with the duck feeding guy, and he begins a conversation with the duck man by recounting his favorite memory, that being when the judge found him legally incompetent as well as physically incontinent. Duckman sells Beau a solid gold Jennings. Beau heads over to Chuck's, where they engage in a drug transaction, and Chuck happily accepts the gold Jennings from Beau. Was this okay? Remember, just because something is really cool doesn't make it legal. No, literally every single part of that transaction was unfortunately illegal. So the thrust of the matter here is that no, not all straw sales are illegal under federal law when it comes to firearms. All transactions knowingly giving a firearm through sale or gift to a prohibited person, though, are illegal. Knowingly lying on a federal form is also always illegal. Where the form is involved and there's multiple people in the chain of ownership, the big question is going to be whether the person filling out the 4473 was the actual purchaser. And we also know that when you're making a purchase as a bona fide gift or without the instructions or payment from anybody else, you are the bona fide purchaser, generally speaking. Now, there was one major case that came to the United States Supreme Court where this was explored, and that was in United States v. Abramski, where a former Virginia cop offered to buy his uncle a gun with his police discount. His uncle sent him a check for $400 with Glock 19 written on the memo line. A while after the sale, Abramski was suspected of a bank robbery, and his house was searched, where federal agents found the receipt for the gun. They decided to track the gun down, and in the course of that investigation, Abramski admitted that he bought it for his uncle, thinking nothing of it. And the feds charged him with violating 924A1A, and the Supreme Court unfortunately upheld his conviction. This wasn't a terribly just outcome. There was clearly no malicious intent. Abramski and his uncle were, at that time, both eligible to possess firearms, but the government loves its forms and demands you treat them with the utmost respect. Of course, with private sales, it's a different story. No form? Well, 924A1A doesn't play the same way. As cool as it would be, you still can't go running guns for your drug dealer, though. All that said, with the holiday season coming up, bona fide gifts, as long as the receiver isn't prohibited, are generally good to go. Well, that's it for today, guys. As always, I super appreciate y'all watching and subscribing. If you want to support me more than that, I started up a Patreon and I've got a Subscribe Star too, where I've got great benefits for you guys. This kind of support will help me to make more content more regularly, which I really want to be able to do. There's also a link to merch, including the Magic ATF balls, as well as affiliate links in the description down below. Thank you all so much for watching, subscribing, and for all of your support. Y'all take care.
Like,